Yes, ma'am.
Good morning, Your Honors. My name is Cynthia Vincent Thomas, and I represent the defendant, Mr. Munoz. This case is before the court this morning as this matter was transferred sua sponte from the appeals court onto this court's docket. And it appears that this court transferred the matter shortly after the United States Supreme Court issued its opinion in Bull Cumming versus New Mexico. And it is the defendant's position that this case comes within the purview of Bull Cumming, and thus the admission of JZAC's testimonial statements either during the direct examination, which under Barboza was not admissible, but also Hatchett's opinion that the substance was cocaine and weighing 19.9 grams violated the Confrontation Clause because the defendant in this case, like the defendant in Bull Cumming, was not able to cross-examine him to any appreciable amount.
Could I ask you this question? And I don't know if this, I want to know if this happened. There is a gas spectrometer, and I take it that there is paper that comes out of that, correct?
My understanding is yes.
It seems to me, I mean, couldn't, who's the second of the?
Hatchett?
Yes. Couldn't, I'll just call him the substitute.
That's the in-court analyst.
The substitute analyst. Couldn't, as in Barboza, couldn't he look at that, the paperwork of the gas spectrometer testing that was done by the first analyst and form an opinion as to whether the substance was cocaine, and couldn't he testify to that opinion, even though the gas spectrometer paperwork was not admissible?
No, Your Honor, and the reason why is because the printout, if you want to call it the printout, although he did look at the data also from JZAC's notes, is testimonial hearsay. And it isn't just...
I know it's not admissible for that reason, but that doesn't mean he couldn't base his opinion on it, does it?
He could not base his opinion on it because my argument is it was a testimonial conclusion on the actual point that he was going to testify to. It was a conclusion. It was JZAC's conclusion. The pen is blue. He looked out the printout. The pen is blue. He made no independent analysis. There was nothing that he said that was any different than JZAC said, because all he looked at was a conclusion.
So that's my question. If he had, I'm sort of comparing this to Barboza. If there was evidence that he had looked at the paperwork of the gas spectrometer test, it seems to me that's comparable to looking at the paperwork of the DNA stuff done. Couldn't he have testified, I looked at this independently and I looked at the way the graph came out and the colors or whatever, I forget what it looks like, and it is my opinion that indeed this stuff is cocaine. Couldn't he have done that?
No, Your Honor, because this case is very different from Barboza. Because now in Barboza, they're looking at the DNA profile. The in-court expert isn't testifying, yes, I have an opinion that the profile is the profile. You know what I mean? The out-of-court expert says the profile is A, B, and C. The in-court expert is not there to say the profile is A, B, and C. The in-court expert in Barboza is to testify with regard to the identification of the defendant. A very separate and distinct conclusion. He simply is taking the data from the out-of-court analysts, saying, okay, this is a DNA profile. I'm going to take this DNA profile, I am going to compare it to the others, I am going to do my analysis, make a statistical formulation, and then I am going to opine that the defendant can be either included or excluded as a possible source of the DNA. It is separate from. They're not simply looking, yes, the DNA profile is A, B, and C. I concur. I concur because I see it's A, B, and C. They're taking it, the base evidence, and coming up with a different conclusion. They're not asked to simply repeat the conclusion of the out-of-court witness. And that's why this case is so much closer to Bull Cumming than it is to Barboza, because the defendant's constitutional rights, he cannot confront Hatchett because Hatchett has nothing more to say, is not in the court for any other reason but to testify to exactly what JZAC testified, his testimonial statements that he performed his testing at the lab.
Okay, but I thought Hatchett said that he had examined Jasic's notes and also examined the results of the gas chromatograph.
It's a little confusing if he looks at the notes with regard to the cocaine, but he definitely looks at the notes with regard to the weight. But I would agree. He looks at the
gas
file.
chromatograph.
Absolutely.
And if I were to look at the gas chromatograph, I would have no clue what it means. But he's an expert and he knows what it means and he can read that gas chromatograph. And how is that different from looking at the DNA profiles that was done in Barboza? They're looking at raw data.
Right.
Raw data that would mean nothing to a layman, but that an expert can look at and say, I know what that means. That means this substance is cocaine.
It's different because he is not making an analysis. He's simply saying, I see the chart, and the chart has the frequency of cocaine, and I know that because I know the frequency of cocaine, and simply translates that to the jury. Instead of explaining, this is the pieces of the atom for cocaine and this is what cocaine is, he is only acting as a conduit. I am translating what this peak means to you, jury. It means cocaine.
Isn't that the same thing that Kelly Lynch, if she was the one, in Barboza is saying, I look at this and I see that the alleles come out here and,
right.
and that means X, because I know that.
Right, but that's not her opinion. Her opinion is not solely the DNA profile that was conducted by an out-of-court analyst. That's not what she's
part of her opinion.
But that's not what she's there for. The issue is confrontation, correct? So at least in Barboza, my understanding of Barboza is that, and my distinction here is that at least the defendant had something to cross-examine his accuser on the issue of identification. Madam in-court expert, what statistical analysis you did, why did you do that, how did you do that, why are you including him, why is this allele so unique? I can ask all these kind of questions. What questions could he really ask of Hatchett? So, did you look at the data? Yeah, it said cocaine. Okay. Anything else?
So that means that the more certain the analysis, the less admissible it becomes?
It has nothing to do with the certainty of the analysis. It's who is doing the analysis. JSAC could have testified, I prepared it, I put it in the vial, I looked at this machine, okay, and that was the last part of my analysis, and my opinion is it's cocaine. He could do it.
Okay, but let's be realistic. 2010 is the trial. Testing is done in 1994.
Correct.
If you had Jasic there, do you think there is any chance that Jasic's going to say, oh, I remember that cocaine test. I can tell you exactly what I did apart from my notes. Isn't essentially Hatchett in the same position pragmatically as Jasic is when he testifies? He can look at what was done from the notes. He can look at the gas chromatograph. He can offer an opinion. Why would Jasic be able to do any more 16 years later?
Well, they could testify his proficiency. Well, how often did you ever make mistakes? Did you ever get tired and just say, did you make mistakes sometimes? Because back then they hand wrote things. Did you make mistakes sometimes? Yeah, maybe I did. Were you ever disciplined? Yeah, maybe sometimes. But, I didn't put any of that in my notes, so no problem here.
Let me ask you.
I think that you're limiting the right to confrontation because the confrontation isn't an issue of reliability. It is, the right to confrontation is not, the whole line about not the scientific ability of Madame Curie or the honesty of Mother Teresa. It is to be challenged in the crucible of cross-examination. And without Jasic there, the defendant simply didn't have that
And you didn't
opportunity.
object. Trial counsel didn't object to this
No.
testimony. And this was after Melendez-Diaz, after Crawford versus Washington.
Right, but before Bull Cumming.
But
Oh, I'm
so
sorry. Yes,
you didn't object. It was after
Absolutely.
Crawford. It was after Melendez-Diaz.
Absolutely.
So you agree that the standard we use is substantial risk.
Absolutely.
Okay.
So let me return to a question that Justice Botsford asked, and it was about what comes out of this gas chromatograph. And let me just read a sentence from Bull Cumming. The New Mexico Supreme Court stated that the number registered by the gas chromatograph machine called for no interpretation or exercise of independent judgment on the analyst's part. Does that mean that it's more like a breathalyzer and less like a DNA machine?
I think it's more, it looks like more like the DNA kind of thing with the peaks. But my argument here is that you can't separate the printout is part of JZAC. Whoever does it, it's the end conclusion. Before, they used to do wet chemistry. That would have been the final step. Now we have machines, so the machines do the final step. But it's all interrelated. And this doesn't mean this applies to every kind of case, but this is the kind of case where the analyst takes the substance, they prepare the substance, it's their call, or their judgment, or their lack of proficiency, or their lack of honesty, all the things they talk about in Bull Cumming. It's all that preparation to the final step. They just don't do the wet chemistry anymore. Now they let the machine do it, but that doesn't mean the machine has any independence of its own. It's only based on the product that is put in. If it's the correct product, if it was numbered properly, if it was labeled properly, if it was packaged properly, if it was put in the machine properly. That's the type of testing that we have here, and that's what makes it different. Because how can the defendant be able to question Hatchett or his accuser, actually JZAC, about his honesty, proficiency?
Well, what if this were a breathalyzer test and it was a different kind of a case?
I think
and wait a minute, and the police officer who administered the breathalyzer test retired because the defendant had defaulted, and so the case comes to trial 10 years later. They introduced the breathalyzer machine or the test result from the breathalyzer machine. Is that admissible?
No.
Why?
It's not admissible, and actually, even under statute, I believe, they have to have that they have to view them for so long, they have to make sure they don't eat anything for 20 minutes. It's the same type of thing. There's the process.
So somebody comes in and said that if somebody else comes in and testifies to all that.
Well, if they were there and they saw it,
Does
sure.
the breathalyzer printout get admitted into evidence?
No.
Why not?
Because it is, again, the end conclusion of the input of the breath. Before the breath can go in and the machine can work properly, it has to have a proper sample. They cannot eat, they cannot, burp, they can't, do a lot of things, and they have to be observed for the 20 minutes before the breath goes into the machine. It's the same type of process. It is a machine, that's all that it is. It's only as good as the data that goes in it. And the data that goes in it is testimonial in nature. These chemists are there to get evidence for trial. It isn't just raw data where, somebody's sitting in, and there's looking at some sort of graph of, seismic activity. And then they decide, oh, well, this is interesting because maybe we're going to have an earthquake next week, but that's not testimonial in nature. Somebody can look at that graph and come up with an opinion about something. It's not testimonial. Here, the work of the analyst is testimonial. They know that they're preparing this for trial, and the machine is just part of their analysis. And that's what makes this very different from raw data. There's no question that it's testimonial in nature.
Well, in any event, quite apart from the gas, I've seen both words used, chromatograph or spectrometer, your point about the weight is that it's clear that all that Hatchett did was read the...
Absolutely.
Just base it on the facts that were stated in the notes.
Yes,
and
absolutely.
Say, if you take 4.03 from whatever, you get 90 whatever.
That's right. And he did no analysis that the jurors could not have done on their own. It was all based on the weight of the plastic baggies and the weight of the cocaine. And it's no different than the example that the court made in Bull Cumming, where if a police officer uses a radar gun and writes in this police report, I used the radar gun and it was 100 miles an hour, the police said, the court said, could another police officer come in and read that report because it's a printout of the radar gun? And the court said, absolutely not, based on our precedent. And that's the same exact thing here. You cannot separate the machine from its testimonial nature because of how the tests were conducted.
Does it make a difference who, that it was a supervisory capacity here?
No, Your Honor. I think that that type of language in Bull Cumming meant what they were actually observing the individual doing the testing at the time.
And would that have made a difference if this was a person who had observed the testing at the time?
Bull Cumming suggests that at that point they would have watched it and they would have been able to testify that I saw him put this number and I saw him put that number there. And I mean, I think they could, if they could testify to that, then they actually observed the test. Mm-hmm. And I think it's different.
Could I just ask you this question on the other issue, the past recollection recording?
Yes.
What was the What do you say the basis was for the defense counsel to put in Detective Donnelly's statement? Police report?
My understanding from when he actually offers it, it's part of the discussion about the prior recorded statement. He says the prosecution can't put in the prior recorded statement during the direct examination, but during cross-examination, you can put in the report of the prior recorded recollection.
But why is it helpful to the defense to have that in there?
That is my ultimate argument here, is that it was simply ineffective assistance of counsel. He obtained no strategic benefit from this. The only benefit that I could see, and I did write that in my brief, is that to show that the passenger had been arrested in Lawrence on a drug
cases. And your defense, the defense was that these were the passenger's drugs. Sounds pretty kind of important.
Right. And then for that, we get the defendant's fingerprints are in the FBI lab, and they were able to identify him, indicating he had prior bad acts. We get to bolster Decker's credibility with his own prior consistent statements. We get to bolster him with Donnelly's out-of-court testimony that's not even subject to cross-examination. And then we get to put it in writing so the jury gets to see it all in the jury room.
Am I wrong? I thought all of that had come in oral testimony and direct, and it was just the actual physical police report that was admitted in.
That's right.
Yes.
So
Right,
all
so
this evidence was before the jury in any
more than once.
Yes.
More than once, when really Decker is the only witness against the defendant, and there really was an issue as to possession and knowledge.
Well,
and intent to distribute.
you can't blame the fact that there was not a second witness. Your client was on the run for 16 years, and the police officer died.
That's right, Your Honor, but that doesn't lessen the Commonwealth's burden to prove its case beyond a
course not.
reasonable doubt by letting Decker testify only.
Can I ask you a question? Was there an instruction on
Prior
flight?
Oh, flight. Consciousness of guilt.
Consciousness of guilt.
Yes, there was. I'd ask Your Honors to reverse the case in this matter. Thank you.
Good morning, Your Honors. Karen Carlo for the Commonwealth, Berkshire District. Your Honors, it's the Commonwealth's contention that this case does fall within the ambit of Barbosa's decision and is distinguishable from Bullcoming.
Even as to the weight?
Well, Your Honor, I would like to point the Court's attention to the Lineback decision, which is a decision from, I believe, 1990 from the Appeals Court. I submitted a 16L letter recently. I don't know if the Court has gotten it yet. In the Lineback case,
Would you give me the cite on that, please?
I'm sorry, I don't have it right now. I believe it's from 1990.
And the spelling is?
Leinbach.
Thank you.
In that case, now I acknowledge this is before Crawford and Melendez-Diaz. The court stated that the expert testifying about the weight and composition of drugs may rely on a certificate of analysis prepared by another, and that the reports, tests, and data underlying it, because such materials would be admissible if the analyst who performed the test was present.
Okay, well, since the if is not possible anymore, doesn't that sort of destroy the holding?
I'm not understanding your
Well,
question.
in other words, you can't admit the certificate by itself.
Mm-hmm.
So if that case is based on the fact that the certificate would have been admissible, it doesn't seem to me we can rely on that now.
I understand your point, Your Honor. I was just citing the case, the proposition that at one point the court did recognize that that data was the data that an expert could base an opinion.
Oh, I understand you can base it.
Because it would have been independently admissible.
But I guess the problem here is this is an opinion that's a fact. I mean, you can say, yes, it's my opinion, it weighs 16.5, but that's really just saying he says it weighs 16.5.
Well, he did testify that he looked at the data, and performed his own math on the data.
Well, but didn't the data sort of say the whole thing weighed X, and the plastic bags weighed 4.03, and if you take 4.03 from X, you get 90, whatever the number was?
Yes, Your Honor. He did testify.
He's not really giving an opinion about weight, though. He's describing a process. If the chemist who had done this work had testified, he would not have given an opinion as to weight. He would have testified as to the process he went through in order to make calculations about weight, and then stated, here's my math, and I conclude that here's the weight.
Right.
It's not really an opinion, is it?
It's more a description of the process he performs to get to the weight. So if he had testified at trial, that would have been admissible. So the substitute expert should be allowed to testify to that process and to the weight, because
But he's only regurgitating, in this case, all he did was regurgitate essentially what the original chemist or analyst had done.
Well, if that's the court's interpretation, which we're not really conceding, because I think the testimony was a little more complicated than that. But I'd like to point out that he was subjected to cross-examination on whether he could be sure that the original chemist's mathematics were correct and whether the processes were done appropriately. So in that sense, the defendant actually benefited from that testimony, because he could try to convince the jury, which he did try to do in closing argument through cross-examination, that the processes relied upon by the original chemist were flawed without actually having to show that they were flawed. I believe there's case law that states that that's beneficial to the defendant, and that can overcome a substantial risk of a miscarriage of justice in cases like these.
Did he repeat the process of the calculation?
I believe he did so, Your Honor.
He didn't take the bags and weigh the bags.
No,
He didn't
Your
do the
Honor.
weighing, but he repeated the calculation.
He repeated the calculations.
But didn't he just use the numbers that were in the notes?
Yes, Your Honor, because he didn't reweigh it himself.
Can I ask you about that? What is the problem with retesting in this area?
I think the problem that with retesting in this area, and I think one of the cases, it might have been McGrail or mentioned this, that what if that expert that then retested it was not available?
So you're coming up to trial. You find that the analyst who did the original examination is either left the state and really not within the jurisdiction, so can't really come or can't be brought here, or has passed away or something. How complicated is it to reweigh evidence which has been preserved, and how complicated is it to run it through this gas, whatever it is, gastrometer?
I don't necessarily know how complicated it is, but for instance, in this case, the substitute chemist testified that the DA's office requested that they retest it, or asked them their opinion on that they retest it and reweigh it, and they stated that it would just be too problematic for the labs to keep having to retest their evidence because they have this backlog.
Well, they have a big backlog, and I understand that, but I'm not sure that means that the test itself is very complicated. I mean, maybe they even have field tests now that can do this with great certainty. I don't know, but it doesn't sound like a really complicated test. Certainly not on CSI. They just stick it into the machine. It pops right up on the screen.
And I'm not a chemist. I don't know how complicated these tests are. There seems from the substitute chemist's testimony, it appears that there's at least two steps that goes into the substance goes into two different machines, and then they have to read retention times, and it's not really clear from his testimony how long the substance needs to remain in the machine. So I'm not going to concede that it's as simple.
Probably not.
It's probably not.
In Bull Cumming, Justice Sotomayor wrote a concurring opinion in which he talked about certain situations that Bull Cumming was not. And one of them was, she said that this is not a case involving a supervisor of the analyst who perhaps may have had a chance to make some observations about the process or may have even participated to some limited degree in the process. And in this case, I went and looked at a portion of the transcript to see if Mr. Jasek, the original analyst, and Mr., is it Hanchett, the
Yes, Your Honor.
testifying analyst, if there was ever a supervisor relationship between them, and I noticed that Jasek was a much older chemist, had been on the job much longer, and at one point in their careers, Jasek, the actual analyst, was a supervisor to Hanchett.
Yes, it was.
But it wasn't clear whether, when the food lab and the drug lab merged, Hanchett became Jasek's supervisor. Is there anything in the transcript that suggests that Hanchett actually ever supervised Jasek?
I believe that Hanchett testified that Jasek was a supervisor at one point.
The Jasek was Hanchett's
Jasek was
supervisor.
Hanchett's supervisor
But
at
is
one
there
point.
anything in the record that suggests that Hanchett, that the reverse occurred?
No,
Okay.
there isn't, Your Honor.
Okay. So the witness who testified was never, at least according to the record, the supervisor of the actual analyst.
No, but he was acutely
Worked together. They overlapped.
acutely aware of the process that
Yeah.
his supervisor would have taken in regards to this evidence, and therefore he was subject to cross-examination on that issue.
But Hanchett was a supervisor at the time of testimony. Did he
Chief of the
testify?
lab, I think.
But he did not supervise
No, he did not.
Jasek at the time this work was done.
No.
Okay.
Could I turn you to the past recollection recorded?
Yes, Your Honor.
Putting aside for the minute the defense counsel's, moving Detective Donnelly's report in, why would the prosecutor be able to use Detective Donnelly as past recollection recorded? I mean, I understand theoretically the idea that the testifying officer, whose name I'm forgetting.
Decker.
What's his name?
Detective Decker.
Detective Decker may be able to do it because he's talking about his own report. But how does that exception to the hearsay rule get to Donnelly?
I believe it's the Nolan case that states that someone can use another person's writing as a past recollection recorded if they adopted it as true at that time. And Detective Decker testified that he reviewed his own report and Detective Donnelly's report at the time when he's coming up with, I believe, his Rule 3 report, his probable cause report, and that he adopted. And
So it was treated as Detective Decker's past recollection recorded? Is that what it was treated as?
Yes.
Oh, I see. Because that was another question, but I guess that solves the problem. Another question I had was whether Detective Donnelly was even on the scene, but it didn't seem that he was. Because he said these people were there, and he didn't mention himself. But what you would say is it wouldn't matter because Detective Decker clearly was.
Right.
And if he was adopting it for himself, then
Right.
it wouldn't matter.
Right. If there are no other questions, we'd rest in our brief.
Thank you.
Thank you.